basically, the first step is what we call the charge, and that is that either party has determined or is of the belief that a portion of the statute has been violated. So basically, they draft up the charge and they file it with the FLRA. That is the first step in the process, is we consider the charge. The second step then basically is the investigation by the FLRA. So what is that? Once the FLRA receives the charge, they will look at the charge and then make a preliminary decision whether there's enough evidence that's been presented by both parties to determine whether or not to proceed with this action. Now, as a first-line supervisor, how does that affect you? Well, it affects you in the sense that if you are named in the charge, the FLRA may want to talk to you. But I caution you that if that were to happen, please inform your LRO or your local attorney that a charge has been filed and that you have been summoned to provide testimony or to be investigated or interviewed, if you would, basically. And you would be represented by either the local attorney that's assigned to your base to handle ULPs or by your LRO. I said you will not go it by yourself. But it's important that you do cooperate and that you, to the best of your ability, provide as much information as you can. That's the second step. The third step is what's called the initial determination. What does that mean? That basically means that after the charge has been filed, the preliminary investigation has been done, they're going to determine whether or not there's sufficient evidence that has been presented to warrant our fourth step, and that would be the complaint. So with that, the FLRA will then take all the information, assess the information, and make a decision. If there is insufficient evidence to support the charge, chances are the FLRA is going to dismiss or at least make a request to dismiss the charge by the charging party. Why is that important? It's important because it doesn't establish any precedents, or either party can refile the charge again, maybe this time provide more information. But if enough information has been presented, then the FLRA can make the decision and issue what we call a complaint. Now here's where the neutrality of the FLRA stops. If a complaint is issued, that means that they have determined that there's enough information in there that we believe, or the FLRA believes, that either party did violate the statute. So, short of a settlement agreement as to how do we resolve this, then the fifth step is adjudication. Now this is where the FLRA, basically their agents or basically their attorneys, will now act as prosecutors and prosecute you, the agency. Now, what I failed to mention earlier is when the charge is filed, it's filed and it names the installation commander, irregardless of where the violation occurred. So if you as a first line supervisor did something wrong or allegedly did something wrong, then that charge is filed with your installation commander. That is a very important key part of that. So, getting back to the adjudication portion of it, once this is where you actually go to a hearing before an administrative law judge, and here's where your attorneys will represent the agency. The FLRA will then attempt to prove or the allegation that was charged against the agency. Now, the last step is the decision. Once the administrative law judge hears all the evidence, here's the testimony of all the witnesses, then basically what's going to happen after that is a decision will be rendered. They can either sustain the charge or find that there was no merit to the case. If that happens, that's what we, from the agency, we would consider that a victory or a win. But if the decision goes against the agency, there are several aspects that can happen here. Number one, the FLRA does have the authority to undo what you've done. And that is, if you, let's say for example, move some employees from one building to another, change in working conditions. and you fail to notify the union, then the FLR has the authority to put those employees back. Now, that could be costly, could create backlog. It's just unbelievable. They have that authority. In addition to that, you will post a notice throughout the entire installation where all bargaining unit employees work that says the agency, violated the statute and we're hereby ordered to, and then the order will be given. And that gets posted for about 60 to 90 days. So there are some implications of what can happen if you violate the statute. Well, the best thing to do is know the law. Work closely with your union reps. Develop some type of relationship that's positive. That will go a long way. Understand the rights not only of the employees, but also understand the rights of the union. Says, develop a working relationship, a positive working relationship. Work closely with your LRO. Before you do something that will create a change, find out first, is it really a change? Do I need to notify the union? What do I need to do to make sure that I don't violate the union? So basically, become educated with the statute, become educated with your collective bargaining agreement, establish good working relationship with your union counterparts. Because in the end, they are your partners, and the closer you work with them, the better things will be, and will make life a little easier.